This appeal arises out of a petition instituted under Article 137, Clause 1 and 3 in the Constitutional Court. In essence, the appeal and cross-appeal are against the majority decision of the learned justices of the Constitutional Court regarding the competence of the military courts, their ability to render a fair hearing, offences triable in military courts, and persons subject to the jurisdiction of the military courts in Uganda. The background. When he filed constitutional petition number 45 of 2016 in the Constitutional Court, the respondent was a civilian and member of parliament representing the people of Nakawa municipality, Kampala Capital City Authority, KCCA, in the 10th Parliament, and shadow minister for KCCA. He filed the petition against the backdrop of events following his arrest, where he was arraigned before the General Court Martial, GCM, and charged along with others with offences under the Uganda People's Defence Force (UPDF) Act. To wit, offences relating to security contrary to Section 130, subsection 1, paragraph F, with the particulars thereof being that he contrived to plot with others to overthrow the government of Uganda, and treachery contrary to Section 129A, with the particulars thereof being that he infiltrated the UPDF or was an agent of a foreign power or any force engaging in war or warlike activities against the government of Uganda. He objected to his trial in the GCM, contending that he was not subject to military law as he had no military connection, and that the GCM was not a competent court under the Constitution to try any of the offences with which he was charged. But the GCM overruled his objection. He filed a petition in the Constitutional Court challenging the provisions of the UPDF Act number 7 of 2005, which he singled out in the petition, and acts of the UPDF of arresting, detaining, and remanding him to prison in relation to the charges against him, as being inconsistent with the Constitution. The proceedings in the GCM against the respondent were stayed by an order of the Constitutional Court. He prayed for a permanent injunction to restrain the appellant from continuing those proceedings. The Constitutional Court partly allowed the appeal in its majority decision, where it inter alia held that as a civilian, the respondent was not subject to military law and could only be lawfully tried by a military court if he were charged under Section 119, subsection 1, paragraph G of the UPDF Act, as an accomplice to a principal who was subject to military law. And the principal was so named in the charge sheet. There being no principal named in the charge sheet, the court held that the charges brought against him were null and void and of no effect. The court also declared Section 1191H of the Act, which allowed military courts to try persons for offences provided for under other laws outside the scope of the UPDF Act and constitutional. According to the court, Parliament never intended that the UPDF Act should be an act of general application, since it is a statute of special and limited application. Hence, the unlimited and original jurisdiction of the GCM referred to in the UPDF Act only apply to offences under the Act. Last, the court examined the nature of the military courts and held that first, military courts lack all the tenets of an ordinary court established under Chapter 8 of the Constitution, particularly under Article 28(1). Second, they are tribunals, and third, they are not part of the judiciary. The court accordingly ordered the petitioner to be released forthwith. The appellant was dissatisfied with the decision of the Constitutional Court, hence it appealed to this court. The respondent, for his part, cross appeal against the decision, allowing civilians in certain cases to be tried in the military courts. The grounds of appeal are: 1. The learned majority justice of the Constitutional Court erred in law in finding that sections 2 and 179 of the UPDF Act are in contravention of Articles 28(1) and 44(c) of the 1995 Constitution, and that the GCM is only competent to try military disciplinary offenses under Part 6 of the UPDF Act. 2. The learned majority justice of the Constitutional Court erred in law and fact in determining that the GCM cannot be impartial or independent, is inconsistent with Article 28(1) of the 1995 Constitution of Uganda, and does not apply the principles therein to persons subject to military law. 3. The learned majority justices of the Constitutional Court erred in law and fact in determining that charging and arraigning the petitioner before the GCM was inconsistent with Article 28(1) and 44(c) of the Constitution. 4. The learned majority justices of the Constitutional Court erred in law in finding that Section 1191H of the UPDF Act is inconsistent with Article 28(1) and 44(c) of the Constitution. The appellant prayed that the appeal be allowed. The decisions of the learned majority justices of the Constitutional Court cited be set aside, and the appellant be awarded costs of the appeal. The cross appeal. The respondent cross appeal on the following one ground: that the learned majority justices of the Constitutional Court erred in law in holding that a civilian can be charged before military courts as an accomplice together with a person subject to military law. He thus prayed that the cross appeal be allowed, and part of the decision of the majority justices that he has impugned be set aside or reversed. Consideration and determination of the appeal by this court. The appeal first came up for hearing in this court in 2022. From that time to its final disposal today, it has suffered an unprecedented affliction by a host of adversities. There is thus an imperative need to clarify on what transpired within that period. The grave and persistent series of events that characterized the lifespan of this appeal began with the fire gutting the chambers of the Chief Justice on the Supreme Court building at Kololo on the 27th April 2022, followed by water flooding parts of the building. This resulted in a condemnation of the Kololo Supreme Court building as being unfit for occupation, thereby leaving the justices of the court with no office accommodation. Thereafter, two justices of the court, namely Justice Paul Mugamba and Justice Ezekiel Mwanguzi, who were part of the original panel for this appeal, retired. This therefore necessitated a reconstitution of the panel. In November 2022, the court was able to secure a temporary home, and more justices were appointed to the court. The court then embarked on the process of reconstitution of the panel, with a view to sitting by December that year to rehear the appeal. However, that December, we suffered the devastating demise of Honorable Justice Ruby Awere Opio, who had been on the original panel for this appeal. This necessitated awaiting the appointment of additional justices of this court for the requisite reconstitution of the quorum to take place. However, in only 6 months thereafter, yet another tragedy struck this court with the demise of Justice Stella Arach Amoko in June 2023. It was until January 2024 when 2 more justices were appointed to the Supreme Court, whereafter the court was able to reconstitute the panel for this appeal. The appeal came up before the reconstituted panel on 13th May 2024 in the new Supreme Court building at the Judiciary headquarters, upon which the learned justices reserve judgments to be delivered on notice. Notice has been served on the parties for delivery of the judgment today, and that's why you are here. So the delay in this case did not take 4 years, as some people, including members of the learned profession, have dishonestly been feeding the public. Judgment in this case delayed by 8 months, from May last year to today. If you did some arithmetic at school, you'll find this is 8 months, not 4 years. But let me say this also. This is a court of law, court of judicature. The court does not belong to the Chief Justice, does not belong to the justices and judges of the various courts of judicature. It belongs to all of us. It's our property. It belongs to you and me. If you're part of those who bring politics, come to play their politics in this court, you're fighting yourself. You're piercing your own eyes with your fingers, with your nails. Because for as long as you will need this court, the court you're trying to delegitimize, the court you're throwing mud on, is the one you will run to. That's not to say courts, judicial officers shouldn't be criticized. As a matter of fact, if people do not criticize, it means you're doing nothing, and they ignore you. Criticism makes the best out of the person. But please, what you can do in the political field, and some of us have been there, should be different, whether you're a lay person or you masquerade as a lawyer. Please, this is your home, and for many of you, this is your marketplace. Let us use constructive criticism. Let us engage with the Chief Justice, with the judicial officers, with the administration of the judiciary, so we have a better institution. Each time we improve on it, because this is like a hospital. At some day you must go to a medical center. So you will come here, your relatives will come here, anyone who seeks justice will come here. So if your purpose is to destroy the judiciary as an institution, it's like democracy. You may not know the worth of democracy until it is taken away from you. Sometimes we take air for granted. Until somebody closes your nose, then you know how important air we can take for granted is. So my appeal in itself, and then on behalf of judicial officers, criticize me every day, walk to my chambers and say, Mr. Chief Justice, how can this be? Write to me, because it's not my property. It belongs to all of us. But this idea of thinking that you can gain fame, you want to be known, you learn how to write in social media, thinking you are attacking the Chief Justice, you are attacking yourself. And I ask all these people, please read A Man for All Seasons. You are cutting that forest which you need when the devil begins chasing you. So I thought I should say this and then read my judgment. But also let me add, let nobody go fearing that, oh, I have stepped on the foot of the Chief Justice, now he's going to bear ill will against me. No, we as judicial officers were taking the type of oath you have not taken.